We'll start
Okay.
at 9:30, President, or 9 o'clock, President Bach, or 8?
Yes.
8 o'clock.
Yeah.
9 o'clock
9 o'clock.
until
If you
4:30.
say 8 o'clock, it'd be a problem. I'm just letting you know.
Okay, 9 o'clock until 4:30.
9 o'clock is much preferred to 8 o'clock. Yes.
Or
Wonderful.
Yes.
Wonderful. Okay, I'll send notices. Thank you.
okay, thank you for enthusiasm.
Some of us prefer the.
Some are retired or prefer the earlier.
Yes.
You
Some have children who need to get to school, and
Fair.
9 a.m. is much easier than
Okay.
waking and.
We've gone with the 9 o'clock.
I appreciate that.
So, we've heard the testimony and the questioning from the commissioners for Mary Shanning, the deputy city attorney. Do you have additional witnesses, Ms. Headley?
Yes, President Bach, we would call City Attorney Evan Goike.
Court reporter, please swear in Mr. Goyke.
No sound.
I'm sorry. Can you hear me now?
Yes.
Yes.
Thank you. Sorry about that. Do you swear the testimony you're about to give here today is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Thank you. Good afternoon, Mr. Goike. How are you?
I'm great. Thank you. Good afternoon.
Can you describe for me how you are employed, please?
I'm currently elected as the city attorney representing the city of Milwaukee.
And what are your responsibilities as city attorney?
I act basically as a department head overseeing the office of the city attorney. It's an office of, I believe, 65, 64 employees, 35 attorneys, 4 deputies, support staff. And, ultimately as the head of the office, I oversee those 4 deputies, the assignment of attorneys, and the representation of the city in the Housing Authority of the City of Milwaukee, as well as the board directors of Milwaukee Public Schools.
What's your responsibility as it relates to employment decisions?
As the head of the office, ultimately, I have the final decision making in terms of hiring and discipline and firing, and we can get into some of those decisions that I've made over time, but ultimately, as the head of the office, it's my final decision.
When you were elected to the position, what were your priorities for the office of city attorney?
There had been, in the 4 years prior to my election, turmoil and a great amount of turnover. I really saw April of 2024, April 16, when I was sworn in, my first challenge and priority was restoring the office culture to a place of trust where people felt safe and supported coming to work. And I would describe somewhat maybe like the logo of the Target store, kind of concentric circles of tasks at hand. The first was to establish my management team that is made up of 4 deputies that are at-will employees appointed by the city attorney. And so I had to make a decision whether I would retain deputies that were incumbents in those positions, and there was 1 vacancy. The next circle out was, I believe there were 9 of 35 attorney positions vacant. And because of those vacancies, a great deal of work and representation displaced onto other attorneys. So the immediate challenge was hire the vacancies and reassign work so that the attorneys had more equitable assignments, and that the office wasn't being carried by a few harder, heavier weight on a few shoulders. And then my next kind of layer out was to really begin reviewing the support staff of the office and what their assignments, training, professional development.
Can you describe for me what, if any, onboarding you had with the previous city attorney?
There was none. I have not talked to the prior city attorney since a candidate forum a week, 2 weeks before the election. And when I was sworn in on April 16, 2024, there were no notes or it's not a job that comes with an instruction manual, but there were no to-do lists or there was no transition or transition team in place.
Do you describe yourself as the chief culture officer of the Office of City Attorney?
Yeah, I refer to myself in that using those words. Internally, I think this is the first external use of that. That's okay. And I referenced that in my earlier comment. My first few days, first few weeks, the prior administration, it was a very strange feeling in the halls of the office. There was a lot of distrust and lack of communication and collaboration. I really wanted to break down the silos that had existed. I could tell immediately that lawyers from one section were not working with lawyers of another section, or a paralegal assigned on to one attorney wasn't, there just wasn't there wasn't a lot of life in the halls. And so I have, from my first day and to this day, try my best to really make an effort to be present, to engage. I frequently walk around the halls with a cup of coffee, checking in with folks. How is their assignment? How is their dog doing? How are the ticks this season? Or whatever the issue of the office may be. But I do that because it fosters a culture of trust and support that was mentioned when I started.
At some point in time, did you have the ability to reassign to Ms. Shanning the supervision of support staff?
Yes.
And do you recall when approximately that was?
Approximately, it was either June or July. Deputy Shanning was the first deputy hire that I made. There was one vacancy. In her testimony earlier, she mentioned that she was originally the deputy over the OED office. That's where a deputy vacancy was. So in order to get her into the office in May, that was the team that she supervised initially. When I made my ultimate decisions I retained Deputy Robin Pedersen, who was a deputy in the prior administration. I moved one deputy over the litigation section down to an assistant city attorney and terminated the employment of the third deputy. And so once I was able to get that team, that first circle I described earlier of the 4 deputies in place, I then was able to reassign some of the duties. Deputy Shanning is the chief deputy. We do not use, and it has since been deleted as a position, but the prior administration had a chief of staff, a special deputy chief of staff. That was not a position that I ever had or wanted. But Deputy Shanning, as the chief, most senior deputy, I thought was the appropriate person. Finally, when I started in April, it was, I believe I was listed as the direct supervisor to a number of support staff and did not feel that I had the capacity to provide the type of review of their work product. I oversee a large office. I did not have the ability to sit and really examine the work product of our business manager or IT or human resources administrator. So I felt I needed to delegate that to somebody that would have the capacity to appropriately supervise and review those individuals.
Did you come to learn through DCA Shanning of any kind of performance issue with Antoine Young?
Yes. Deputy Shanning shared some of the frustrations and complaints of members of the office. Before that, I scheduled one-on-one meetings with each employee in the office, including Mr. Young, and gave an opportunity. That was an opportunity for me to meet the entire staff. And part of the exercise was to learn people's names. And so part of it was biographical. Do they like dogs or cats, or, trying to get to know who they are as people. But many of the staff also took the opportunity to, I asked and prompted questions. What resources are you missing at your work? What things are going well? What things are not going well? And I don't know the exact number, but individuals did highlight concerns with Mr. Young, or challenges with his performance during those individual meetings.
And did you do anything immediately upon receiving this information?
Objection relevance.
I'll move on if you understand that it has nothing to do with performance, but you've brought it up multiple times as a potential issue.
Okay.
We've had, and I want to do the same thing with the department that I've done with the appellant attorney, that this is essentially about the other issue.
Correct.
And so let's keep it very short when it comes to these so-called performance issues, which were considered serious enough to be looked at by the deputy, but from a performance improvement plan perspective. But then that got put aside because this issue came before us, or came before her. So let's keep it very short.
Perfect. Those are the next line of questioning there. So with that information, did you put Mr. Young on a performance improvement plan?
No.
Were you intending, or did you consider putting him on performance improvement plan?
Yes.
Did you ultimately put him on a performance improvement plan?
No.
Why not?
We discharged Mr. Young prior to that.
So I want to talk now about the ultimate issue here before the commission. When did you come to know that there was an issue with Mr. Young accessing the office of the city attorney at the Ordinance Enforcement Division?
I was aware of limited physical access early in my tenure. I would say April or May. I do visit the Ordinance Enforcement Division and in the Police Administration Building. I myself went through the CJIS clearance process. I have the badge that can get get into that building and behind the secure setting into the offices there. There is a satellite office for the city attorney or the deputy overseeing OED, and I have worked out of that location before. In doing so and communicating with staff, it was, I believe, Mary Lyles communicated that to me. I was unaware at that time any of the details or severity of the CJIS issue. Initially, it was the lack of the ability to obtain a badge and physical access.
When did you come to find out that it was not just the physical access to the building, but instead the electronic access to the laptops and the machines?
I think what became it later in 2024, I do not know. I cannot remember an exact date that I was made aware of that. I wasn't where this really became an urgent issue was November 11 or November 12, when I was made aware of and saw the audit that enforced some decision-making points from our office on how to comply with the audit.
Is it fair to say that the sky was falling at that point in time?
Yeah, there was so the sky fell on November 11, November 12. I believe, if I'm recalling correctly, the deadline to submit that audit was November 23. So we had a period of 2 weeks roughly to figure out how to answer the questions on the audit. And earlier witnesses, Deputy Shanning, went through some of the, I would call them options that were explored. Importantly, I could not lie on that form. And there is it's a binary yes or no question of whether or not the individual working on those computers has passed the background check. I felt I could not check yes, because that would be a lie, knowing that by that time, I was aware that Mr. Young did not pass the background check in 2022.
So I'm going to turn your attention now to the potential outcomes or potential options that DCA Shannon mentioned earlier. Were you a participant in the meeting on November 20th, which put Mr. Young on administrative leave?
Yes.
And what exactly transpired at that meeting on November 11th that put him on administrative leave?
Well, it was a necessary meeting. You know, we wanted to make sure that Mr. Young had his rights intact for his employment through this process, which he has invoked. If you're following the calendar, this is now 3 days before we have to answer the question and submit the audit. And so we felt that was the only option that we had in order to maintain our compliance and access to CJIS was to place him on administrative leave. We were going to continue to look at some of the options. He brought some of those up in that meeting, but that we had to submit that document timely, and that, you know, we didn't have another option. That it is in my office, it's a position of one. There is no opportunity to demote Mr. Young to a subordinate role or to laterally transfer him. We have one IT administrator professional. And so I was really looking at, in my mind, two options. Lie to the federal government by checking a box that I knew to be false, or placing him on administrative leave with the possibility of separating.
Did you look towards Mr. Young's thought process that he could get his record expunged and be able to work?
I did have a conversation with Mr. Young about that. I have some background in this. Briefly, I worked as a state public defender in criminal courts in Wisconsin, represented hundreds, thousands of individuals with in criminal cases. For 12 years, I served as a member of the Wisconsin State Legislature, and I worked as hard as I possibly could to change what I would argue is an outdated and unjust expungement law in Wisconsin. Mr. Young, under my analysis, as someone very familiar with this law, is caught in a very difficult position. A felony conviction may be subject to a pardon by the governor, not misdemeanors, but due to his age, older than 25 at the time of the commission of the offense, he's ineligible for expungement. So he's stuck. And I did that review, as I have done that review to many, many people over the years working as an advocate and legislator in this area. It's a pretty black and white law to know that he was not going to be able to remedy his conviction status.
Did you indicate to Mr. Young that he had the potential to get reinstated at ITMD?
Yes,
Okay. Did Mr. Young seek that reinstatement?
it's my understanding that he did, yes.
I'm sorry.
It's my understanding that he did seek reinstatement.
It's your understanding that he would be, it would be possible for him to be reinstated at his position at ITMD?
Correct.
Is that ultimately your decision, your call to make?
No.
I believe you spoke you did speak briefly about Mr. Young's position being a position of one. Did Mr. Young ask you to create a second position specifically to work at the Office of Ordinance Enforcement?
One of the suggestions in that pre-discharge meeting was the idea, which we explored, could our 9 employees, 5 lawyers and 4 support staff that work out of OED and need and rely on CJIS clearance and those database, could they be supported by whether that's a limited term employment or an IT professional in a different, in the Milwaukee Police Department or in ITMD, we did explore that. Ultimately, those departments felt they did not have capacity. We explored that, but I don't have, I don't have the budget authority to have a second IT professional. So I would need the Common Council and the mayor to give me that authority and to fund that authority, or to fund that position. I will also mention, I do not see the 9 employees at our OED office as different than or other than the lawyers at the Zeidler Municipal Building. I actively try to take down those divisions. Being physically separated can lead to, not knowing one another or not working on assignments. We are actively working to have those lawyers and those support staff work on items of that we handle here at downtown, and vice versa.
I want to go back to a statement that you made about the option of potentially working with another agency or another department within the city to have IT resources for OED. Do you have control over other departments outside of the Office of the City Attorney?
No.
Can you mandate or order the Milwaukee Police Department to work with your staff at OED?
No.
Can you order or command the municipal court to work with your office at OED?
No.
Can you order or command ITMD to provide these services to the folks at OED?
No.
But you did explore the possibility of asking them for that assistance.
Correct.
And they all said they could not.
They said they could not. There's two distinct issues. One is capacity, those those departments having their own duties to fulfill. The second is our office does have unique IT needs, one of which we've been talking about a lot in this hearing, CJIS. The others are not unique to the lawyers at OED, our case management software. We use a system called ProLaw and are moving to a system called Legal Files. The lawyers at OED do not work exclusively on databases governed by the CJIS policy. They too also work on cases and legal opinions and guidance to departments or the Elections Commission or whatever the special assignment may be. So those attorneys at OED, while they have extra access through their CJIS clearance, they also have the basic access to our unique system. So let's say limited term employee or a member of the Milwaukee Police Department's IT division would not have training on the half of their job that is shared with the attorneys at the Zeidler building. And so I can't speak for those department heads that ultimately made the decision, but it wasn't going to be a fit because of the unique needs of the work that the lawyers do there, as well as capacity.
Is it fair to say that you reviewed every option provided by Mr. Young in his previous meeting?
I feel I did.
When you came to the conclusion, I'll ask you this. Did you come to the conclusion when you reviewed all the information that Ms. Shanny was able to prepare for you?
Yes.
All right. And what the conclusion was what?
That we had to terminate Mr. Young.
Did you do that for any basis other than what was identified in the in A1, or I'm sorry, in the discipline or the discharge the separation notice?
No.
Is there anything else that you wish the commission to take into consideration in rendering a decision?
I just add, it was not an easy decision or one taken lightly. I like Mr. Young. His workspace is immediately outside of my office, and so it was necessarily one of the first people I met when I got the job. Mr. Young asked for an office because there was a cubicle and it lacked privacy. And I said yes to that when the prior administration had said no. Mr. Young ultimately was placed in a former deputy's office, which, I mean, I have the nicest office in the office suite, but it is not a small office. It has windows, a closed door, etc. Had it painted the color that he chose, I felt that was appropriate, that he deserved that. He is someone that I referred to myself culture officer. Those were things that Mr. Young did well that I appreciated. He helped with tasks that he took pictures for our website when I was on the dunk tank raising money for a charity. I like that kind. I value that kind of contribution to the office. Yes, there were performance issues. Yes, eventually we would get to some type of performance improvement plan. The type of performance issues he was having, I think, were manageable and achievable through a PIP. We ultimately couldn't get there. I did speak with Mr. Young after I made the decision to terminate him. He had called the office and asked to speak with me. I spoke to him after hours, and I made it clear to him this is not a personal decision. I had no choice. I don't know how I could comply with the audit form. How could I check yes that we have complied with the background checks required? How could I check no when that individual would have, I was placed in a box and had no other option and felt the only course I could take was to terminate Mr. Young.
Do you feel like Mr. Young was performing all of the essential job functions? You were here for the testimony on Exhibit A18 and heard DCA Shanning's testimony. Do you agree with her analysis that Mr. Young was likely not performing every single job function on that job description?
I agree with that analysis, and I think that's why there was discussion and movement towards a performance improvement plan. Ultimately, there is a barrier to some of those critical functions, and we've discussed that, and the commissioners have heard testimony of that the direct physical access and then the access to the actual machines themselves make it impossible for Mr. Young to provide the IT support to the 9 staff that work in the OED Police Administration Building.
Thank you. At this time, I have no further questions for City Attorney Goyke.
I'm ready if you are.